Good evening, all. It is now 7 o'clock, and welcome to the Licensing and Public Protection Committee meeting being held today, Tuesday, the 24th of October, 2023. Usual protocol for members that we are being recorded and broadcast live on YouTube this evening. If you do have any comments or questions, could we please talk into the microphones when asked to do so? Okay, we'll move on to the agenda for this evening. Part one is licensing. Number one of the licensing is apologies. I've received apologies from Councillor Simon White, Councillor Rupert Adcock and Councillor Joan Wheeldon. And it's been substituted for them this evening is Councillor Barry Panter, Councillor John Tagg and Councillor David Hutchinson. Are there... say again, John? Okay, Councillor Diamond. Okay, apologies from her. Are there any other apologies? No. Okay. Item 2 is declarations of interest in relation to licensing matters. Do any members have any declarations of interest for the licensing business this evening? No. Okay. Item 3 is the minutes of a previous meeting. The minutes for the previous meeting of this committee can be found on pages 5 to 8 of your agenda. Are members content and happy to note them that they've been read? Is the correct record?
Chair, my name's missing off them. Just to let you know.
Say again, Anne-Marie, I didn't catch that.
My name's missing off them. It just needs adding to the minutes.
Right, okay. We'll be done. Not a problem there. Item 4 is the first substantial item of business this evening, which is the fees to be charged for the licensing of scrap metal dealers, gambling and sexual entertainment venue 2024 to 25. This report is found on pages 9 to 14 of your agenda. I will now hand over to Matt, who will present his report to you this evening. Thank you.
Thank you, Chair. Good evening, members. Yes, the report is one that comes to you annually. It's for the fees to be charged for scrap metal, gambling and sexual entertainment venues for 24 and 25. The report is to bring to you our proposed fees and charges for ones that we can amend. A lot of the other ones that are already in the statute, so we can't change them, but they are listed for information. And the recommendation is that the committee agree to the fees to be charged, and they would come into force from the 1st of April next year. Just a tiny bit of background. Full council have delegated powers to this committee for this function. So it is the duty of the committee to set the fees. In relation to gambling, there are some fees that we're allowed to set within a range, whilst most others are statutory. So you'll see in the table in a moment which ones are frozen by statute and which ones are ones that can move. Sexual entertainment venues, they're wholly set by local authorities. There is no statute on those, and scrap metal dealers is exactly the same. Section 2 of the report has a bit more in relation to sort of the legalities of fee setting, which I won't go into, but I can take questions on if there are any. Section 3 is the proposal of the fees that we're putting forward to you today. The first one, which we call sort of general licenses, the sexual establishments and the scrap metal dealers, we're proposing an increase of 4% on those. The Gambling Act ones are either statutory, as I've said, or we've already reached the top scale that we're allowed to in terms of the range of fees that we can set. We're not proposing any increases across any of the gambling premises at all, other than the casinos, which is one that where we clearly we don't have any, but that is a fee where we have not reached the statutory maximum. So again, we've gone with the fairly standard acceptance of 4% on top of those. Section 4 gives you a detail as to what we've included in terms of fees and charges, or what can be included in local fee setting. and the options that we've considered in relation to when we can recover our costs at most. If there are any questions, happy to take them, but the recommendation is that members approve the table at section 3. Thank you.
Thank you, Matt. Any members have any questions, comments for our officers? Councillor John Williams.
Thank you, Chair. Just out of interest, how many scrap metal licenses are there? The collection ones? Have you got that? Yeah.
I don't have the exact figure. It's approximately 15 or 16. Overall.
Oh, right, thank you.
So it's not a huge amount. Certainly not as many as there were when the Act came in 2013.
He's done a good job, the Act has, hasn't he? He's stopped a lot of the...
It certainly has, yes.
Yeah, thank you.
Any further raises of hands? So we'll move to the recommendations. Are members happy to approve the recommendations set out? Yes, I think that's clearly carried. Item 5 is Gambling Act 2005 consultation, measures relating to the land-based gambling sector. This report can be found on pages 15 to 34 of your agenda. I'll hand back over to Matt, who will explain and present his report.
Thank you again, Chair. Yep. The Gambling Act 2005 was a big shift in gambling. It's been a while now since that came into force in 2007. This is the first time that the government have actually looked at making any changes in relation to the land-based gambling sector. There's obviously been a lot of talk and a lot of change in relation to sort of remote gambling, internet gambling, and the operators, but that's not something that the local authority deals with. They're dealt with separately by the Gambling Commission. So this is the first time really that we've ever had a say in changing something that really affects us. So for a bit of background, a government white paper was published in April 23, which looked at the Gambling Act, a review of it and how it could be brought forward for what they call the digital age, for more present and going into the future. Part of that white paper, one of those areas in the white paper related to land-based gambling. There were 5 other main themes which are at 1.3 of your report, but I'm not going to spend any time on those because that's not the focus of the consultation. That's the main part of this report. In section 2, it refers to and it mentions the consultation that we're going to be speaking about today. The closing date has passed, so it is for members to note what we've responded with. It has been responded to in conjunction with the chair for opinions, and you're able to see what we've responded with at Appendix A of the report. But essentially within the consultation, there's 5 main sections. One is in relation to the relaxation of casino rules. One is machines in arcades and bingo halls, cashless payments on gaming machines, an introduction of a legal age limit for certain gaming machines, and licensing authority fees. At 2.6 to 2.10, I've made a real sort of brief synopsis summary of what our responses were. In relation to casinos, we've not really offered any response. We don't have any experience of them. We don't have any of them. And we didn't feel particularly well placed to provide any evidence on that basis. Machines in arcades and bingo halls, they're suggesting, because there's currently a ratio split as to how many machines of certain types you're allowed to have in certain premises. It's called an 80-20 split. They're proposing to change that ratio, and we've provided our opinion on what proposal the proposals they put forward, what we think would be the most beneficial, and we've done that on the balance of allowing operators to meet the customer demand, but also to help and retain and improve safeguards that are already in place or could be put in place when making machines available for use. Cashless payments on gaming machines. when the Gambling Act came out, this wasn't a thing to enable people to tap and go, or to put a stake limit. This is something that's they're looking into to introduce for now and for the future. And they were asking a lot of questions within the consultation around, should there be cooling off periods? What's the maximum time limit for transactions? Should staff sort of be keeping an eye, or to have an overview of what people are spending and the time that they're playing? So we've responded accordingly in terms of that, saying, yes, we think there should be cooling off periods. There should be maximum limits. The staff should be able to stop people from playing, and so on. So we appreciate that times are changing, but also we think there needs to be some safeguards there to maintain the licensing objective of protecting vulnerable people from gambling harm. In relation to gaming machines and a legal age limit for 18, most game machines are 18 plus, apart from the lower category D ones. This is very specific, that there are some category D machines that look like category C and D and B and higher stakes machines. So it looks like it is an adult machine effectively. So what they're proposing is that they make those machines so that they have to be 18 as well. So it's not, so children don't start playing those and then sort of lead on to the same machines, which are at higher stakes and higher prizes. So we've agreed that that should be the case. And again, it will help protect children and vulnerable people from gambling harm if they were to do that. And finally, the fees. So you've already heard, because we've put that report first, most of the fees are statutory. We don't have any say over them. There is a range for some of the premises licenses, so the betting shops, the bingo shops, the arcades. Those fees haven't changed since 2007. The gambling, the DCMS, who oversee the gambling side of things, have suggested a 10%, 20% or 30% increase. We've given our indications to what we think is appropriate. Because we have so little in terms of premises, we actually are pretty much balance the books in terms of our fees, but there are other local authorities that do not and cannot recover all of their costs. So we've responded on that basis. So it's just a recommendation really for members to note that the consultation has taken place, the answers that we've given, and at some point in due course, we'll see the response from the government in terms of what they're proposing.
Thank you, Matt. Any members have any questions for either Matt or Nestor? We'll start in, as I've seen them, Councillor Sweeney first, followed by Councillor Brown.
Thank you, Chairman. It's not a question; it's an observation, really. I think I don't use these gambling machines. I don't really understand the technology on them now. It's a bit complicated, not like the old one-armed bandits. But I think when I was a kid, you put money in, and then they decided you could put notes in as well, 10s and 20s, and that become dangerous again. And now you can just put a credit card number, whatever, in. So it's the way of the world, but I think it's a very, very unsatisfactory situation, really. It just makes gambling very, very easy, and I think it should be made harder. There's nothing to do about it. It's what people are like. But I think yeah, that the notes, and now it's cards, and it's a vicious circle. It's going to add badly, really. Thank you.
And sorry, just a quick comment about that. Some of the points within the consultation were about what safeguards need to be put in place to try and make it as safe as possible. So there is recognition that there does need to be some safeguarding in there. There do need to be limits. There do need to be opportunities for people to cool off and self-exclude from premises and machines, which there already is. But I think in our view, and probably the government's view from reading between the lines, it needs to be stronger. So hopefully, when whatever comes from this consultation, hopefully that'll come to light.
Councillor Brown.
Thank you, Chair. I've got two questions. Firstly, about enforcement. How do we verify the age of the player? And secondly, on question 3.3a on the consultation, I was wondering why you didn't commit yourself to suggesting cash payment limits, Matt, on there. You didn't specify, even though it's a mandatory response. Yeah, on page 27.
What should the maximum transaction value
That's
be for direct
correct,
cashless
yeah.
payments on gaming machines? Yes, I didn't commit. It was a mandatory response, and one of the answers was that you could pick was I don't know. I must say that there was a fault with the consultation in that you couldn't actually print out what you'd put into the consultation. So I've had to pick out the questions and then manually type in what our responses were. So it was a bit of a flaw. But in terms of the maximum transaction value, we don't really, again, have that many premises. We don't have that much experience of what people are putting into these types of machines. It feels like if we don't have the experience, rather than have a guess, we should probably be sort of clear and an objective and say we just we can't offer an opinion on that, which is what we've done for most of the casino questions, if I'm honest. What we have done in terms of the response is look at whether or not they should have cooling off periods. So even if they are putting in whatever the limit is, they should then still have a period of time where they can no longer play. And at that point, if they do go back onto the machine, that is a safeguard that will hopefully be reintroduced or introduced when the legislation gets amended. But we didn't feel qualified to put a figure on it.
What about the second point about enforcement?
Yep, coming on to that one. In relation to the enforcement, we have an officer within the team who deals primarily with Licensing Act and Gambling Act for compliance and enforcement. We have a number of, as I say, we have a number of premises, a smaller number of betting premises than I'd say most local authorities. We also have a few adult gaming centres, which are the ones that sort of you have to be over 18 to go in to use the machines. We also have some family entertainment centres where younger people can go in, and there's a mix of the types of machines. Typically, they're the ones that are actually on the motorway service station. That's why we've got those. So our officer will, although obviously not over COVID, will go to those premises. They'll carry out compliance checks. There is a sort of a standard form that a lot of local authorities use to check what safeguards are in place, what staff are in place, is the signage there, what machines do they have, are they compliant with their conditions. So we do have someone that goes out and does that. And in relation to the specific point around how do we check the age verification, that's a condition on every license that the operator then has to comply with. It's like in a pub, you have to check to make sure someone's 18 when they go to the bar. Same thing, if someone's using a machine and they don't look 18, they have to challenge them, and if they're not 18, they're not allowed to do it. Most premises and most gambling premises specifically operate now the challenge 25 rather than the challenge 21. So even if you look under 25, they should be challenging you to make sure that you are actually 18 to use those machines. So all the operators that we have that we are aware of do operate challenge 25 and make those checks.
Thanks for your full answer, Matt. Could I just quickly ask whether you've got records or examples of when your enforcement officers found that people underage have been using it?
We don't actually have any sorry, we keep records, make that clear, but we don't have any incidences of our gambling premises having had people underage. There is a national test purchase operation that goes on. The betting premises you'll find and the gambling premises you'll find are actually very good. It's more of a problem with gaming machines in alcohol licensed premises that actually cause a problem. They're more likely to fail a test purchase than otherwise, because even though it is their duty to make sure that people who are playing the machines are old enough, they have other things going on. So we do sometimes get complaints about that. We go and investigate. We haven't got anything specific any specific concerns at the moment, but we do know it's a problem, and that's a bigger problem than it is actually in like betting shops.
Good to hear about your safeguards and the balance to try and ensure minimisation of gambling harm. Thank you.
First point, Councillor Brown, I think where you're asking the question on what the maximum transaction value should be, if these machines, they will not have an insert point for the card, they react on the chip and pin. Now, if you know yourself, use your chip and pin so many times, it will then be cut off. So that would be down to the individual banks, and most banks are on top of that, whereas they will only have a certain limit of amount. So yeah, to be fair to the officers, very difficult in answering that, but it's also a case of the question I asked, the limit of a go. So can you put like £50 on or £100 on each time that you click? Don't know if that was mentioned during the consultation, was it?
Not specifically, no. But I think what will come out of this, they've obviously asked the question in a particular way because these are limits that they're thinking of or are proposing that might be a choice. We won't know until they decide, the government decide what they're going to go with. I would fully expect it to be either to be a tap or a chip in pin, and they'll have an option potentially of up to whatever the maximum is, and they'll select whatever they use, and then they'll play their games. And at that point, once they've reached their limit, that is where we expect there's a cooling off period of whatever it is, where they can't then immediately tap and go again, or insert the card and go again. So it is a little bit, we don't know what the idea is that they're proposing, but as long as they have, I think in our view, that they have those cooling off periods and they have those people monitoring it, that's where you get your safeguards in terms of limiting potential harm and vulnerability.
Councillor Skelding, do you have any advice or thoughts on these, with you being a lot more in the know?
Not that I'm a gambler or anything in any way, but just one thing on point 33A again, rather than a limit being set, a lot of casinos, they do operate an affordability check. So because on gaming machines, what's affordable of £20 to one individual, someone can afford to lose £100,000. So a lot of casinos now, they have a trigger point. Once that's reached, they tend to ask for proof of if the gambling's sustainable, whether it's a bank statement or employment, what they do for a living. And the manager of the outlet has to ask the questions personally. Otherwise they'll suspend the playing. So are there any plans for the government to impose something like that on gaming machines?
Nothing in the consultation about it, no. Casinos are quite often sort of set apart in relation to all of the other betting premises because of the type of activities and because of the level of stakes and the types of games that they undertake. So there are very special conditions. So there is, go back a step, there are standard conditions on every single type of gambling premises license. There's different conditions for betting shops as there are to casinos, as there are to bingo, as there are to adult gaming centres. So they will have conditions on that talk about stakes. They'll also have their own internal policies and procedures as to how they think best to promote the licensing objectives of not allowing vulnerable adults or vulnerable people and protecting children from harm and those things. So there's nothing in the consultation, no. There may be something in the white paper in relation to some of the betting premises, but certainly nothing that they've asked about on this.
Thank you, Matt.
Councillor Fanta, thank you for your patience.
Yeah, thank you, Chair. In relation to question 38C on page 29 about mandatory time limits and calling off periods, does it apply to per machine or per individual in any one premises?
The good thing is it wouldn't be us implementing it. It would be for the operators to do in their shops. It isn't clear. Cooling off periods in other gambling sectors usually refer to the individual. So I would expect it to be on that individual. Quite how they deal with that, rather than someone moving from one machine to the next machine to the next machine, if they're available, I don't know. But that is something I think that time will tell when the consultation is concluded and the responses are let out.
To speak on this item? I think that's a no. So we will move to the recommendations. Are members happy to note the contents of this report? Yes, I think that's clearly carried again. That concludes the licensing matters for this evening. We will now move on to the public protection. So item 6 is declarations of interest in relation to public protection matters. Councillor Sweeney. Yes, sure. Okay, now that everyone's acquainted, item 6 is declarations of interest in relation to public protection matters. Do any members have any declarations of interest? Item 7 then is public space protection order, parks and open spaces. The contents of this report can be found on pages 35 to 56 of your agenda. I will now hand over to Michelle, who will present her report to you.
Thank you, Chair. Good evening, everybody. Thank you very much for having me back again. So as members will be aware, this is another report to the committee in regards to the outcome of the final 6-week consultation that was conducted in regards to the proposals for a public space protection order in relation to parks and open spaces. I'm sure you're aware the council, the reason for this is for the council are seeking to use its powers to prohibit, to restrict and control defined activities relating to dog control and alcohol consumption in parks and open spaces across the borough. If members can refer to section 3 of the report, I will guide you through the consultation results that were taken over this summer period. As part of the consultation, this included an online consultation and also included a number of interactions from officers within the MMF team interacting with members of the public out in the parks and open spaces. So a full copy of the consultation results can be found attached to this report as Appendix B. But some headline findings just to identify for you. So overall, there was general support for all the proposals that are being put forward. The highest support was in regards to requiring a person in charge of a dog to clean up if their dog fouls in a public place. Another quite obviously keen recommendation was in regards to keeping dogs on leads in crematoriums, cemeteries, churchyards and unfenced children's play areas. And the lowest support was for the requirement for dogs to be kept on leads in open spaces owned by towns and parish councils and excluding dogs from open spaces owned by parish and town councils. On the whole, 92% were in favour of restricting owners to 6 dogs in each mentioned location, and 56% agreed that dogs should be kept on a lead on marked out sports pitches. If I can refer members to Appendix A, you'll be able to see a draft copy of the proposals in the report. These are the recommendations that we are putting forward for members to consider and to consider the content of this report and to give approval for the public space protection order for parks and open spaces to be granted by the Borough Council, which will allow us then to pursue on enforcement of that order. Happy to take any questions.
Members, Anyone like to speak on this? Just Councillor Panther. Councillor Panther, please.
No, it's quite a simple one. Where is Appendix A? It doesn't appear to be attached here.
It should be in the file. Chair, I don't know if you can refer to what page it's actually listed on.
I think it might be on page 49.
What page? That's the consultation. Is it? No.
43.
This is Appendix A.
Sorry.
Oh, that's that, isn't it?
Yeah, 43, yeah,
Oh,
yeah.
it didn't say appendix, that's why.
Yeah.
So right, it didn't say appendix, that's why I was puzzled.
Councillor John Williams, while we wait. for
Thanks,
Councillor Panther.
Chair. I agree to most of this, and it's really important for people to enjoy our open spaces. But enforcement, we need to have these orders put on, but who's then going to enforce it? That's you don't see many people going out, whether it be through body cams, is that the word? Because you need visual evidence before you can prosecute. I'm sure I'm right in saying before you can prosecute anybody. So have we got enforcement with body cams? Thank you. You know, photographic evidence. Thank you.
The enforcement of a public space protection order will be undertaken by authorised officers from Newcastle Borough Council, and that will predominantly be from the MMF team who will be out on patrol in these locations. Body cams are something that we are considering as a local authority. It isn't something we've got at the moment, but it is something that we are looking to see if that is a viable option for us in terms of our enforcement activities across a range of different enforcement areas across the local authority.
Supplementary, Chair. You need photographic evidence? I'm right in saying that, or will eye contact, and then the enforcement officer can find the person, or do we need photographic evidence? Thank you.
So the difficulty with the enforcement around, if you're talking specifically around members of the public witnessing an offence, is obviously identifying the individual, identifying the dog was with that individual. It may be that, you know, we are able to identify somebody if you present us with photographic evidence and a statement to that effect of what you've witnessed, but a lot of it will come down to the fact that we need to identify the person who's actually responsible for that offence.
Thanks, Chair.
Councillor Hutchinson.
I'd just like to comment that section 3.7, the means to pick up dog fouling, something that I'm really very, very pleased to see in this report. As somebody who has 2 dogs, every coat pocket I have, every jeans pocket has dog poo bags. I don't go anywhere without a supply of dog poo bags. So in this, I'm pleased to see that if a person in charge of a dog shall be guilty of an offence if at any time he or she does not have with them or her the appropriate means to pick up the dog fouling. Is this something new, or is this something that we've always had that, and maybe we didn't enforce? Thanks.
So this is not new. These the conditions that are in Appendix A are a continuation of the public space protection order we currently have in place across the borough. It is something we've enforced, but again, it comes down to obviously officers being on the ground and enforcing that, but it isn't something new that we're looking to add.
So you can follow up, Councillor Hutchinson.
If a resident knows of a person who doesn't pick up after the dog, if they logged it with the council and said there is a resident who takes the dog out every morning at 7 o'clock and doesn't pick up after the dog, are we able to maybe position somebody for 2 or 3 days just to see if we can catch a resident and maybe, you know, give them a penalty fine? Thanks.
Yes, absolutely. So we already have a running list of hotspot locations where intelligence has been passed on to the team. And we do have officers who will be out and about on those key dates to deal with them matters.
Councillor Jill Williams.
I'd just like to say, I agree with the majority of this, but I would like it noted, I'm still against 6 dogs on leave. 4 is adequate, but 6, I am really against, and I'd like it noted, please.
Thank you, Councillor Jill Williams. It has been noted, and it has been noted in previous meetings. I'm sure it will be again. Do any other members wish to? Councillor Brown.
Just a very quick one, Michelle. You said you would have officers from, I think you said the M&F team. Could you just say who they are?
The MMF team is the mobile multifunction team. So they are a new team within the Borough Council, and they are an amalgamation of a number of enforcement officers from across the local authority who are being multi-skilled, multidisciplined in terms of tackling a range of community safety and environmental crime offences.
Further questions to Michelle? Are members then content that the recommendations are set out in the report is accepted? I think everybody agrees. Okay, so item 8 is the Clean Air Act of 1993, consultation on the revocation of existing smoke control areas and declaration of a new borough-wide smoke control area. This report can be found on pages 57 to 84 of your agenda. I will now hand over to Darren, who will present his report to you.
Okay, thank you, Chair. Thank you, members. This report is brought to you tonight really to show the importance of air quality and how seriously the council takes the issue of air quality. As you'll see in the report, there are a number of costs associated with poor air quality, and in particular, fine particulate matter, which is an issue for domestic burning in particular. You'll see that the costs to the local economy are significant, the costs to the NHS are significant, and the costs to the UK economy are also significant, and that costs each one of us in our taxes. Also, it tends to affect the more vulnerable in society. So people who haven't got a choice, who are newborn or elderly, they tend to suffer more from the impacts of poor air quality. As the report shows, the impacts of fine particulate, these are particulates that pass into the lungs and into the bloodstream and then find their way around the body. That thickens blood, that lodges in different parts of the body, causes cancers, contributes towards strokes, and generally has a debilitating effect on long-term health. In Newcastle, we can see that we've had around about between 70 and 90 deaths per annum attributed to fine particulate matter. So if I just take you through the report now, the background I've just gone through, that is explained in section 1 of the report. And you'll see there's various tables and also a comparator table of deaths from fine fraction deaths associated with particulate matter within the statutory authorities compared to England. And the next graphic, figure 3, that shows the impact of domestic burning in terms of emissions from open stoves compared to a more modern type of stove, which is the lighter brown colour, and then down to electric fires. You'll see there that solid fuel open fires do tend to emit a significant amount of fine particulate. And it must be emphasised that there is no accepted safe level of fine particulates by the World Health Organization. So although in domestic legislation the government has imposed a limit, that limit is still considered by the World Health Organization to not be protecting health. So section 2, in terms of the current smoke control arrangements, we have a number of existing smoke control areas. These were declared principally following the smogs in London in the early 1950s. And those, we've got about 40 smoke control areas, and those are shown in Appendix 1. So you'll see there that there's still significant parts of the borough that aren't protected by smoke control areas. So in essence, that means that residents in those areas are free to burn whatever they want on their domestic fire, so long as it doesn't cause a nuisance. And that can generate a significant amount of smoke and cause issues for local residents in those areas. And as you'll be aware, the more rural areas of the borough, Baldwinsgate, Loggerheads are coming in for a lot of development, and despite obviously our desires as a council to resist those developments, obviously national planning policy is in favour of such developments, and those locations aren't currently covered by any smoke control arrangements. So we're left with statutory nuisance powers in the main. So what people are required to do in a smoke control area is to burn smokeless fuel, or basically not to emit smoke from a chimney. It doesn't mean that they can't have a fire. And indeed, we acknowledge and accept that in the current circumstances that people will choose to burn because it's in some cases cheaper than gas or electric, and we accept that and we understand that. But nonetheless, it can't be at the cost of people's health. So what we're looking to do is to modernise the smoke controls for the borough. And as we say in section 2.7 onwards, the reasons why we're doing that is that we've got significant gaps where people aren't protected by smoke control arrangements. And we're also seeing a resurgence in the popularity of domestic burning in the home. Excuse me. So many people will think that this might be a restriction on domestic garden fires. It isn't that. It is purely a restriction on smoke from a chimney of a building. So such as what you'd use to heat your home, not a garden bonfire, not your barbecue, and not an open fire in the garden on a warm summer's night when it's going a bit cooler. So those are currently untouched, except if they're causing a nuisance, and we're not we can't bring those into scope. It's purely smoke from a chimney that we're looking to control. So in section 2.14, the government has modernised the Clean Air Act. Traditionally, what we were expected to do was to identify a property burning that was emitting smoke, and then to undertake a prosecution. Obviously, that's very resource intensive. So much like other environmental legislation, they now offer a fixed penalty. And we've adopted approach based on DEFRA guidance as how we would go about handling fixed penalties. And in the report, you'll see a fixed penalty policy at Appendix 3. In essence, what we're required to do is to go along, identify smoke from a chimney or have a complaint about smoke from a chimney where we might write to somebody, give them a warning, and then if we see a further incident of smoke emitting from that chimney, is then to issue a notice of intention. The notice of intention basically advises the householder or the person in charge of the premises that we have witnessed smoke and that we're proposing to issue them with a fixed penalty notice of a set amount. That gives them a right of appeal to the head of environmental health, and we then, if they decide to exercise their right of appeal, then we then go through considering the grounds of why they consider that fixed penalty not to be appropriate. Ultimately, it is one that the head of environmental health would have final say over as to the whether to issue a fixed penalty and also the amount of that fixed penalty. And you'll see in the case of persistent burning that we would be going to the maximum amount allowed by law of £300. The minimum amount we can impose is £175. So we are proposing to cover canal boats as well. They can be a significant source of smoke. We don't have any residential moorings within the borough, but we do have overnight moorings, and the canals, as you probably appreciate, tend to be in areas that can be quite challenging for smoke dispersal in cuttings close to existing residential properties, particularly in Kids Grove. And those themselves can be a significant source of smoke nuisance and also fine particulate. So in terms of the options being considered, it's considered stay as we are. But obviously that means that the existing smoke controls that we have, we would just be able to enforce those. We wouldn't be able to deal with an increasing popularity of smoke emitting appliances, particularly in rural areas and these larger villages that are that have got permission, or indeed on some of the green spaces within the urban areas which weren't originally covered by smoke control areas, such as Woolstampton Colliery, for example. So we do feel that we need to modernise our smoke control order and to go borough-wide, because we feel it's unfair to discriminate and to subject any of our residents to what is essentially an unsafe particulate. And World Health supports that. This also fits in with the UK's the English air quality strategy as well, where there are a specific focus on fine particulate matter. So we've gone down into section 6 of the report. We've explained the legal implications, and again we've drawn attention to fixed penalty notices there. Should we serve a fixed penalty notice, then there is a right of appeal to magistrate, not a magistrate's court, but a specialist tribunal. Section 7, we recognise that people could be suffering fuel poverty, and that might be the reason for them burning. And obviously, with current grants and various initiatives, including council initiatives, we would be signposting people towards those in the hope that those are taken on board and they have the best advice possible to avoid committing any further offences, and also to bring people out of fuel poverty. Currently, in terms of grants under financial and resource implications in section 8, as we've got no more residential moorings within the borough, we're not in a position to pay grants to canal boats, and the grants to fund adaptations to existing properties or properties that are affected by the smoke control legislation or smoke control orders, they are no longer applicable. The government have taken those away. Yeah. So the recommendations to committee. Is that the committee approves the making of the Newcastle-under-Lyme smoke control revocation order 2023. That approves that, and that be published for formal consultation as detailed in Appendix 2. That the whole of the administrative area of the Borough of Newcastle-under-Lyme be made a single smoke control area, and that is approved through the making of the Newcastle-under-Lyme smoke control order 2023, and again that is approved for formal consultation. That the formal fixed penalty charging policy for smoke control offences in Appendix 3 is approved, and that's officers bring back a further report to committee following the consultation period of a minimum period of 6 weeks to give you an update on representations received. Okay, I'll be happy to take any questions.
Any members have any questions? Just Councillor John Williams.
Yeah, thanks, Chair. As one who can remember the smogs of years ago and the effect that had it on the health of people, you know, we've come a long way, without a doubt. It's very interesting to read the report. And I think I can't see any reference to industry. We haven't got many heavy industries now in the area. You talk about the domestic fires and the smoke from those fires. Is industry measured in the same way?
Industry would be covered, but the majority of the polluting industry now is covered under separate bespoke environmental legislation. So such as the foundries that are still in existence in the borough, we regulate those for emissions from chimneys and fuel emissions. The brickworks we also regulate. Those are the most significant industries within the borough. Again, those are regulated for emissions, energy consumption as well. So they contain permit conditions which do not allow them to emit smoke. And anything that we don't regulate, which is regulated by the Environment Agency, I'm just trying to think of any particular processes other than the landfill. There's BOCM pools at Park House that's regulated by the Environment Agency. Again, they contain that their permit contains a condition relating to emissions from chimneys there. The industrial estates around the borough, we've long had a policy through planning of approving the chimney heights and also what they burn. And those aren't a significant source of smoke emissions. Indeed, most of those estates operate on gas or electric. So in comparison to domestic burning, where people are burning wood in the main or damp wood or painted timbers or treated timbers, those are a relatively small source of fine particulate pollution. Okay.
Councillor Panther.
Yes, thank you, Chair. In relation to section 7.3 on page 62, if someone hasn't got the financial means to paying fines like this, how long would it take them to get this energy grant, whatever it refers to here? Otherwise, they're going to be getting away with basically blue murder when other people are paying fines.
Yeah, the various grant schemes, we don't really have, as a local authority, that much control over. Obviously, conditions and eligibility criteria vary over time, and dependence on obviously the state of the economy and government funding. But your officers will keep pace with those and work closely with officers and housing team to identify properties that may be eligible for some form of financial assistance from the Borough Council, for example, towards paying of gas or electricity bills to ease that burden. But ultimately, what we're seeking, and it shouldn't be beyond the means of anybody really, is not to emit smoke from a chimney. So long as somebody is burning dry, clean timber or suitable fuels, there shouldn't be an emission of smoke from the chimney. And if we do end up serving a fixed penalty notice and it's not paid, then that becomes a civil debt, and that would obviously result in the council's debt recovery policy being invoked.
Any further questions? Councillor Hutchinson?
Thank you for the report. I'd just like to make a comment. I welcome the report. There should be one rule for the whole borough, not one rule for Maybank and a separate rule for Baldwinsgate. I think having one borough-wide rule makes sense, and I look forward to seeing the results of the consultation period.
Thank you.
Okay, if there are no further comments or questions, are members happy to approve the recommendations that are set out in this report? Okay, that's agreed. Item 9 is the private hire in Hackney carriage fees and charges for 2024-2025. Contents of this report can be found on pages 85 to 90 of your agenda. I'll pass back over to Matt, who will present his report.
Chair, this is another one of those reports that comes to members every year. We have fee setting power for our taxi and private hire trade in terms of applications and processes that we undertake. This report is sort of the primary or preliminary report, really, where we inform you of what we're proposing in terms of our fees. There's then a consultation, and then we come back with consultation responses for a final decision. So those are the 3 recommendations that we're going to be putting to you tonight. In terms of the background, similarly to the other fees that you've heard tonight, it's a committee function. It's been delegated from full council, so it does fall within the powers of this committee to do that. Within section 2, there's some legal information as to how fees are set within the Act. The fact that we have to consult for a period of not less than 28 days if we're changing vehicle or operator license fees. We don't have to consult upon changes to driver fees, but we do because it's considered good practice to do so alongside the others. There's a bit of information as to why licenses have a maximum time period and what those are. And then again, similarly to the other report that you've heard earlier on today, there's some legal section in terms of case law and regulation as to how fees should be set, and it's for cost recovery purposes. It's section 3, which you'll draw your eye to, which is the proposal in terms of the fees. We set out several subsections within that. 3.1 explains how the table works, which is reasonably self-explanatory. 3.2 is the table itself, and I'll take you through some of the bigger changes in just a second. And then sections 3.3 to 3.6 try and give a little bit of explanation as to why certain fees have changed in the way that they have. But again, I'm going to try and cover those for you now. So the first sort of headline, the only fee that's really gone up, other than tiny amounts, which looks like a big percentage, is the private hire operator application fee. There's a couple of reasons for this, and it explains in 3.5. There has been an increase in council costs, but we've also had an issue over the past year or so where we've had to review our procedures in terms of doing pre-application checks on proposed bases. Those of you who have sat on some of the subcommittees will have seen that we've had some licenses issued to bases in the borough which have turned out to be sort of bogus addresses. So we're changing our procedures so we make checks on those bases before we issue licenses. And of course, that incurs more officer time and more compliance. That said, it being a 12% increase, it's £40. It's a 5-year license, if granted, to operate an unlimited number of vehicles and drivers for their business. So we also don't think that it's a disproportionate fee in terms of what they actually get for that permission and authorization. The sort of next headline fee is the dual driver's license, the badge that they get for 3 years, which enables them to drive either hackney carriages or private hire vehicles. Explaining 3.6 of the report, we're proposing it goes down, which works out at about 9%. Part of that is due to some efficiency we've realised as part of the One Council project, some of the processes that we do, also that we've had a reduction of licence holders and amendments to some of the procedures that we undertake when we are carrying out those checks and those applications. We've also looked at how we set our compliance and enforcement elements of the fee setting, and some amendments to that which have resulted in a proposed decrease. And then the absolute biggest figure, it relates to the vehicles, which you'll see have gone down, or we're proposing to go down 23% for hackney carriages and 27% for private hire vehicles. The main reasons for that are similar to the driver application, in that we've changed how we do them in terms of the One Council project. Everything is done online in terms of vehicle applications now, whereas we used to have people in for interviews and appointments for every single one that we did, which incurred an awful lot of officer time. The reduction in license numbers, so we have fewer of them, so we spend a lot of our time doing other work. And then again, we've reset and reviewed how we do our fee setting for compliance and enforcement elements of the regime, and that has resulted in what, for all intents and purposes, is about a 25% reduction overall. So we're quite pleased to put these forward as recommendations. It's certainly something that's going to help boost the trade. There is a shortage nationally and locally of drivers of vehicles, and we're hoping that will go some way to assist them and help them choose to come to Newcastle rather than to go to other local authorities. So as I've said, the recommendations for you this evening are that you consider the fees at table in the table at 3.2. You accept those, that we go out for consultation with the trade and stakeholders, and then we come back to committee most likely in December, and bring the results of that consultation for a final determination. Happy to take any questions.
Any members have any questions or comments, Matt? Okay, I'll take them in the order that I see them. Councillor Panther.
Thank you, Chair. In relation to the fees, you got one here, spot check. Can you explain roughly what that is?
Absolutely. Not trying to be vague. The spot check is where a vehicle has had a test and it's failed, but it's not a major failure. It's something small that needs to be rectified, and the garage need to see it again. So it's not that they need to get the cars up on the ramps, check all of the mechanics underneath. It's that they can see that there was perhaps a duff tire, perhaps, or something that wasn't quite right in some of the lamps. So they make them go away, fix the issue, come back, and there's a fee that can be charged for that. That's what we call a spot check.
Okay, I would have expected to see something like a retest.
So there is also a retest fee, which is under the vehicles. It's the bottom of page 87. We're proposing to be £31. So that is if there's a more significant failure of the vehicle, it has to come in for a retest, and they pay a higher fee because there's more work to be done around it.
Matt, do they not get away with the normal MOT and fails? You've got 10 days.
No, the normal MOTs have the 10 days and free retest. Ours don't have that. There is a discretion on the garage if it is something so minor that they might not charge the spot check. But generally speaking, that is a fee that is available to the council to charge if it's something not very minor, but less major than them getting up on and like doing a full retest on it.
Councillor Hutchinson.
Thanks, Chair. Can I just ask, how do these charges compare with the surrounding areas? Last time I had to take a taxi from the house to Newcastle bus station because I was going somewhere by bus because the trains were on strike. The driver and the car was registered in Wolverhampton, and I made a comment to the driver and he just said you can be registered anywhere and work anywhere. So I'm just wondering how our charges fare with the surrounding area. Thank you.
Yes, we do some benchmarking and see what other fees are, but what we can't do is say, well, they charge something, so we're going to charge this. We still have to work it based on our cost recovery as a maximum. In terms of Stoke, we're relatively similar across the board. There's a few pounds, £10 here and there across the board, but nothing substantial. Wolverhampton is a different challenge. They license people all over the country. They have tens of thousands of drivers and tens of thousands of vehicles and tens of thousands of operators. They have such large economies of scale that when it comes to renewals, if you were trying to compete with them, you couldn't, because it's just, there's so many that go through the door. What we have done as part of some other work that we've done is looked at their initial license fees. So when you first license with them, not just the application fee, but all of the associated costs of getting a disclosure and barring service certificate, doing a medical, going through the training, and all those sorts of things. And we're relatively comparable with that. What we can't look at or what we can't achieve is it's much cheaper than to then renew the license year on year or 3 year on 3 year there. In terms of they're the main two local authorities you'll see in the vicinity. There are some others, but they're the two that we sort of look to the most.
John Williams.
Thank you, Mr. Chairman. I'm really pleased to see that the prices haven't increased other than the cost to the council. But 2 points I'd like to make or ask the question. I asked the same question last year. The failure to attend vehicle tests, that's gone down. And I asked the same question. If somebody fails to come somewhere, it's a cost to the council. So why doesn't that been increased? And also the cost if somebody applies for a badge and get the car, what is, I suppose I'm being lazy in the sense, I should reckon it up myself, but there's so many points in there. What's the cost to an individual if I want to go to get a badge and get on the road? What would be the cost to myself? Thank you.
I'll take them in turn. The failure to attend the vehicle test, which has gone down £1, that is to do with a change in process. So it takes a slightly less time overall in terms of staff costs to do it, which has resulted in that £1 drop. We're not being generous. I'll take that. In terms of the dual driver badge and the cost to an individual overall, there are a number of costs there. So there's the application fee. Everyone needs to have a disclosure and barring service check to the correct standard. That comes in at a certain cost, which you can see. However, if they subscribe to what's called the update service, which they should do, according to our policy, according to statutory guidance, that's at a cost of £13 a year. If nothing changes in terms of they don't get any convictions, they'll never need to do that again. So that'll just keep running. We carry on checks and they will never have to carry out that check again. Medical, they can either get it with their own GP, and they can vary from £50 to £200, depending on what the GP says, or they'll just say they won't do it. What we did do 2 years ago now is we amended the policy to allow other medical professionals to carry them out. There are a number of local companies that do it with registered GMC registered practitioners who carry them out. That's a cheaper, they do them at about £50. There's a knowledge test for new people, for new drivers, that's £20, which again, we're looking at keeping the same. And then as members know, earlier this year, or it might have been just the end of last year when we reported on it, we've amalgamated our disability and safeguarding training. So instead of paying what would have been around £73 in total for the 2 courses, it's now £48 to do it together. So in total, you're looking at £400 for a new person. It is some money, but then when they renew, they don't have to do, they have to do a disability and safeguarding training again. They do have to get a medical, but they shouldn't have to get another DBS. They shouldn't have to do the training again in terms of the knowledge test. So once they're licensed, obviously the costs reduce for when they're renewing.
Let the portfolio holder come in before I make any comments. Councillor Sweeney, please.
Thank you, Chairman. I've sat and conjugated and thought about it, and I'll keep my opinions to myself. Thank you.
All I was just like to comment is I think the report and what work you've done for this has been, you know, very applaudable. You've thought about it in a correct way, and I totally, you know, recommend that what you've put in forward, is my opinion, of course. But yeah, a job very well done. Further questions or comments? Okay, we will move to the recommendations. Are members happy to approve the 3 items of recommendations? Yes, everybody's agreed. Thank you for that. Item 10 is the minutes of the Public Protection Subcommittee meeting. I've been informed this evening that the minutes of the last Public Protection Subcommittee meetings were still being processed, and therefore the minutes will be shared ahead of the next meeting of the committee. So item 11 is disclosure of exempt information, which I have none, and item 12, urgent business. I've not been made aware of any urgent business. So that concludes proceedings for this evening. The meeting of the next meeting, date of the next meeting, sorry, will be Tuesday, the 12th of December. All that's left for me to say is have a good journey home and enjoy the rest of your evening. Thank you.